Good evening. Welcome to the forum, State Constitution, Are Changes Necessary? I'm Sue Jenick, the director of our program domain in the Dane County League and also the chair of our state legislative committee. This forum is presented by the League of Women Voters of Dane County and co-sponsored by the League of Women Voters of Wisconsin. The League is a nonprofit, nonpartisan organization. We take no position on candidates or parties. However, we do and always have advocated for issues that are of importance to society. This forum is being recorded and will be available on our website, which is lwvdanecounty.org. Captioning is available to turn on. This forum will discuss 4 proposed amendments to the state constitution, which were passed in the last legislative session. If passed in the current legislative session, the proposals will be on the ballot for the April statewide election. The 4 proposed amendments relate to eliminating the governor's authority to allocate federal funds, giving the legislature more control over the standards for pretrial detention and bail, restricting eligibility to vote to only citizens, and prohibiting municipalities from using private funds for election administration. Our panelists tonight include Dustin Brown, a senior staff attorney with the State Democracy Research Initiative at the University of Wisconsin Law School. Dustin joined the initiative following 4 years on the law school's legal research and writing faculty and nearly a decade in private practice, most recently with Godfrey & Kahn in Madison. He has litigated in state and federal courts on matters ranging from electoral redistricting, public records access, and defamation to insurance coverage, products liability, and deceptive trade practices. Jerome Dillard is the executive director and one of the founders of Ex-Incarcerated People Organizing, EXPO. He has a long history of working with and for system-impacted people. Based on his own experiences with incarceration, he sees prison as a form of genocide that drains people of hope for their future. Through EXPO, he seeks to restore that hope by advocating for change in the system that structurally discriminates against so many people and their families. His purpose is to ensure that system-impacted people are treated with dignity and respect, and that they receive the resources and support they need to thrive in their communities upon release. Jeff Mandel founded and serves as both president and lead counsel of Law Forward, a nonprofit, nonpartisan law firm that protects and advances democracy in Wisconsin. He serves on several other nonprofit boards, including the Wisconsin Equal Justice Fund, the American Constitution Society Madison Lawyer Chapter, the Aldo Leopold Nature Center, and Beth Israel Center. Jeff has been named a Best Lawyer since 2021 in his appellate practice and commercial litigation, and the Best Lawyers Organization named him Lawyer of the Year for 2023 in his appellate practice. Jeff has represented the State League in lawsuits regarding election issues. Before we hear from our panelists, I will read our land acknowledgement working statement. In owning our past and charting our future, we, the League of Women Voters of Dane County, recognize the indigenous peoples who are the original stewards of the lands on which we now live, while we struggle to learn more about the current and ongoing context of colonialism. League formation began more than a century ago, in 1920, with women's suffrage, but nearly 2 centuries ago, even prior to the 1848 creation of the state of Wisconsin, an 1832 treaty forced the Ho-Chunk to cede their territory of Tijap, or Four Lakes. Both the federal and state governments repeatedly but unsuccessfully sought to forcibly remove the Ho-Chunk from Wisconsin. Truth and acknowledgement are critical to building mutual respect and connections across all barriers of heritage and difference. We continue this effort to acknowledge what has been buried by honoring the truth. In Dane County, we are all standing on the stolen ancestral lands of the Ho-Chunk people. We pay respect to their elders, past, present, and future. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that bring us together today. A working group is being formed within the League of Women Voters of Dane County to acknowledge past trauma while nurturing present and future commitment to action, working together to understand the histories and priorities of Indigenous communities. The League is grateful for the past, present, and future guidance of Wisconsin's Native nations. Thank you. And now on to our program. We will take questions at the end of all presentations. If you have questions, please put them in the Q&A section at the bottom of your screen. Our first speaker is Dustin Brown, who will give an overview of the state constitution and amendment process and address the proposed amendment to eliminate the governor's authority to allocate federal funds. Dustin.
Thank you so much, Sue, and good evening, everybody. Thanks for joining us, and thank you to the League for having me. As Sue said, I'm a staff attorney at the State Democracy Research Initiative at the University of Wisconsin Law School. We are a research hub that focuses on democracy and government in the states. And much of our work involves state constitutions. And so it's thrilling to see so many people here today engaged in the evolution of our constitution here in Wisconsin. To start off this evening's conversation, as Sue mentioned, I'm going to cover two things. First, I'll give you a high-level introduction to state constitutions generally, and the Wisconsin Constitution specifically to provide some context. And second, I'm going to discuss the first of the four proposed constitutional amendments. This one concerns the governor's authority to allocate federal funds received by the state. If you could move to the next slide, please. Some of you may have watched the inauguration ceremony at the state capitol last week. In that ceremony, each of the officials swore to support the Constitution of the United States and the Constitution of Wisconsin. Around the same time, similar ceremonies were held in state capitals across the country, and in each of them, I imagine, officials swore allegiance to both their state constitution as well as the federal constitution. Now, this tells you something about the significance of state constitutions. They are the supreme law of the states, just as the US Constitution is the supreme law of the nation. But state constitutions actually don't get a lot of attention, especially not compared to their federal counterpart. According to one survey, fewer than half of Americans even knew that their own state had a constitution. That's a little concerning because in nearly every state, it's the people, the voters, who actually have the final say in amending their constitution. Now, those of you who are attending today, obviously, you already know that Wisconsin has its own constitution, but perhaps your friends and neighbors don't. So let's start by learning a bit more about state constitutions, just to provide a framework for what we're about to discuss. Next slide, please. Each state has its own constitution. And in certain respects, state constitutions are similar to the US Constitution. State constitutions establish the structure of state government, the branches of government, their powers, how they interact. They also set out fundamental rights. Indeed, most state constitutions open with a Declaration of Rights. But in other respects, state constitutions are actually very different from their federal counterpart. And I'm just going to highlight three specific differences. First, state constitutions are actually a lot easier to amend and replace than the US Constitution. Secondly, the provisions of state constitutions can be far more detailed. Whereas the US Constitution is written in kind of broad, sweeping language, state constitutions can be a lot more detailed. And in some respects, the provisions of state constitutions, they look more like statutes, ordinary legislation in their level of detail. Now, finally, the last difference between the US and state constitutions, it's actually kind of a sum of the other two. The more frequent amendments plus the more detailed provisions, put those together, state constitutions are a lot longer than the federal one. Wisconsin's constitution is about twice as long as the US Constitution, but some state constitutions are many, many times longer than the US Constitution. Now, turning our focus to Wisconsin's constitution, it's both very old and very young. Although Wisconsin was the 30th state in the union, our constitution is the 5th oldest in the country. So why is that? What explains that discrepancy? Most other states have replaced their constitutions, sometimes multiple times, but in Wisconsin, our original constitution from 1848 remains in place. So in that sense, our constitution is old. But it's also young because amendments continue to reshape parts of our Constitution. Most recently, just 3 years ago, when voters approved a Crime Victims' Bill of Rights known as Marsy's Law. So how is the Wisconsin Constitution amended? It's a 3-step process. It starts with the legislature for the first 2 steps, and then it ends with the voters. First, both houses of the legislature approve the language of the proposed amendment in one session. Then in the next session, both branches have to approve the amendment's text again, plus they decide how to capture the amendment's language in a ballot question that's ultimately going to go before the voters. If the amendment has been approved a second time in this second, consecutive legislative session, then the amendment goes to the voters and it's presented as a question on the ballot. So the amendment's actual language is not on the ballot itself, but it's available for voters if they want to see it. Now, each of these steps, it happens by a simple majority vote. It's not the kind of supermajority required to amend the US Constitution. Amendments represent a significant part of the state constitution. In our 175 years of statehood, 146 amendments have been adopted. Now, nearly 200 proposed amendments have gone to the voters. So that means that voters have approved about 3 out of 4 amendments that the legislature has presented to them. It also means that voters have been asked to amend the Constitution at a rate of about more than once a year over the state's history. This rate of amendment, of course, it's varied at different points in history. It hasn't been consistent. And so far this century, we've been in a fairly slow period. In the last 2 decades, only 8 amendments have gone to the voters, 7 of which passed. So if the 4 amendments we're discussing today all made it onto the April ballot, that would be a lot of amendments to consider at once, at least compared to recent history. But it isn't yet clear how many of those amendments are going to be on the ballot. All 4 of them were approved by the legislature in the last session. They cleared step 1. As for step 2, which is passage in this session, the amendment concerning bail, that's already been reintroduced in both houses. There's actually a hearing scheduled for tomorrow, so that's on track. The amendment on appropriating federal funds, that's apparently ready to be reintroduced, but I don't believe it has been, at least as of today. The other 2, no word yet. And time is ticking because to be on the April 4th ballot, an amendment would need to be approved in both houses and delivered to the Wisconsin Election Commission by January 24th. So that's 15 days from today. Okay, so that's how the Constitution is amended. Now let's briefly talk about why the Constitution would be amended. I'm going to give you 3 distinct reasons why the legislature would try to amend the Constitution rather than pass ordinary legislation. First, if the governor is not on board with it, because amendments, basically, they bypass the governor. He does not have veto authority over amendments. It goes directly to the people. Second, if the state constitution already addresses a topic and the goal is to change what the Constitution says, the only way to do that is to actually go in and change the Constitution, which you do by amendment. Finally, if the goal is to supersede ordinary legislation, whether you're looking to existing legislation you want to supersede or prevent legislation going ahead, the Constitution, it's the state's supreme law that would override an ordinary statute. So that's kind of the foundation of Wisconsin's Constitution. With that background, let's turn to the first of the amendments, which I'm going to be talking about. So next slide, please. This amendment, it relates to the balance of power between the governor and the legislature when it comes to appropriating money. What you see on your screen now, this is the joint resolution that both houses of the state legislature adopted in the last session. And as you can see, it would create a new section of the Constitution. It would appear in Article 4, which is the article of the state constitution governing legislative power. And you can see, looking at the highlighted provision, it says 2 things. The highlighted language is the language that would ultimately go into the Constitution. First, the legislature may not delegate its sole power to determine how monies shall be appropriated. And second, the governor may not allocate any federal monies the governor accepts on behalf of the state without the approval of the legislature by joint resolution or as provided by legislative rule. Now, most of the attention on this amendment so far has been on that second provision regarding the allocation of federal funds. So I'm going to start with that, and then I'm going to loop back to the first provision. Next slide, please. Right now, when Wisconsin receives federal funding, the governor decides on his own how to spend it. That is dictated by statute. In other words, the legislature gave this authority to the governor. But it wasn't our current legislature that gave the governor this power. The origins of this statute giving the governor this authority, they date back about 90 years to the 1930s. So this is how things have been done for a long time. Now, these statutes giving authority to the governor, what exactly do they say? The Wisconsin statutes, they empower the governor to accept funds from the federal government and to designate specific state agencies to administer those funds. And the statutes also authorize those designated agencies to administer the funds themselves. It's obviously goes into a lot more detail. It's more complicated than that, but that's kind of it in a nutshell. Now, this amendment, again, the relevant provision, it says the governor may not allocate federal funds without the approval of the legislature. So when it comes to federal funds, this amendment means that the governor would lose his exclusive authority to allocate federal funds. Instead, he would need legislative approval. So what happens to those statutes that I mentioned, the ones that date back to the 1930s? Well, they would be superseded by this amendment because, remember, the state constitution is the supreme law of the land. What prompted the legislature to introduce this amendment? Well, this comes in response to the billions of dollars in federal COVID relief fund that the state received and that the governor administered. So this is an effort by the legislature to, get some of that power back so it has a say in how money like that is spent going ahead. There's also additional federal funding coming in the future from the Infrastructure Act. So this amendment would also affect that. How does the way Wisconsin approaches this compare to other states? Well, 40 states overall, they authorize the executive branch to spend unanticipated federal funds without special legislative approval. So the way Wisconsin has this at the moment before the amendment kind of aligns with what the majority of states do. But most of those states that provide this authority to the governor, 29 of them, they do place some restrictions on that authority. So if this amendment were passed, where exactly would Wisconsin fall? It's hard to say because it's unclear how exactly the legislature would use this oversight authority. Now, ultimately the question is, what do we think about this amendment? As voters, what would you choose to do? Would you choose to vote up or down? I know the league is opposed to the amendment, but I'm going to present both sides of the argument. On a basic level, the amendment comes down to the question of who decides. Who do you want to make these decisions? The governor alone, or do we want the legislature to act as a check against the governor? Now, keep in mind, this amendment, it would control no matter who is governor. So we need to look beyond this administration. But at the same time, as of now, we do have a very heavily gerrymandered legislature. So until that changes, this would only act as a check on Democratic governors. So it's almost kind of a one-way here. An argument in favor of the amendment would be, look, the legislature should have a say in the allocation of so much money. And that's the argument that's been presented by the legislature in support of this amendment. When these provisions, when the statutory provisions giving this authority to the governor were first adopted, the legislature was typically in session for only the first 6 months of the 2-year biennium. Now we have a full-time legislature. So perhaps giving so much authority to the governor isn't necessary. Now, an argument against this amendment, it comes down to efficiency. Giving the legislature a say in allocating federal funds would slow things down. The governor's spokesperson in a tweet about this amendment resurrected some longstanding criticism about what the legislature did during the pandemic, saying the legislature took a 300-day vacation during the worst economic crisis in a decade and the worst public health crisis in a century. So from the governor's perspective, it's much more nimble for the governor to wield this authority exclusively. So that's the second part of the amendment. Now let's, if we could just go back for a moment to the previous slide and briefly look at the first part again. The first clause of this proposed amendment, it says, the legislature may not delegate its sole power to determine how monies shall be appropriated. Now, on its face, this is a more general provision than the second clause. It's not limited to federal funding. It refers to monies generally. So it certainly seems broader than the second part. The state constitution does already talk about appropriation. There's a provision that says no money shall be paid out of the treasury except in pursuance of an appropriation by law. So the question is, how does this provision, this first clause of the proposed amendment, change existing law? You know, that's actually something that's difficult to say. It's open to interpretation, and I'm not going to kind of offer a definitive interpretation right here. But it's something to be mindful of. And ultimately, this would tie the legislature's hands. Whatever this means, it would prohibit the legislature from delegating this authority going ahead. So this would be concentrating more power regarding appropriation in the hands of the legislature. And with that, I will turn it to the next speaker. Thank you, everybody.
Thank you, Dustin. We already have a couple of questions in the Q&A, so I'm sure we'll have an interesting conversation about this. Our next speaker is Jerome Dillard, and he will share with us how the proposed amendment regarding pretrial detention and bail could affect those whom Expo assists. Welcome, Jerome.
Thank you, Sue. It's really a pleasure to be here tonight, and I'm really honored to present tonight to so many people. Well, how this will affect individuals with arrested conviction records is something that's very concerning to me and many of those who I work with. Under Wisconsin Constitution, a person accused of a crime is eligible for release before conviction under reasonable conditions designed to assure the appearance of the accused in court, protect members of the community, and for serious bodily harm, or prevent intimidation of witnesses. Monetary bail may be imposed only upon a finding that there is a reasonable basis to believe that it is necessary to assure the appearance of the accused in court. This constitutional amendment proposed in 2021 legislation for the first consideration does the following. I'm not going to get so much into that aspect of it, but in reading the release that came out, Wisconsin bail policy is a national outliner that makes us less safer. We currently rely on integrity of the defendants arrested for violent crimes, and if it's no surprise that when they victimize more innocent people. I feel that this is pure fear-mongering. It came on the heels of the Waukesha catastrophe. And I know that, individuals are concerned. But few decisions in the criminal process are consequential as bail. Recent research finds pretrial detention imposes long-term costs on the defendants and society. And looking at this, one point I do want to raise is we already have a system where there are individuals lingering in our jails and prisons. And the fact of the matter is many of our jails are understaffed and overcrowded. This proposal that is being presented is just going to further exacerbate the individuals. Oh boy, the individuals who are in our jails, and so defendants are held pre-trial are more likely. I do want to add that the defendants who are held pretrial are more likely to plead guilty, even if they're innocent, to get through the process. Right now, I'm seeing individuals who are waiting 5-6 months for preliminary hearings. That's no exaggeration. I talked to a couple last week who are under that. We know that the public defender's office is understaffed. The district attorney's offices are understaffed. I don't know how this would contribute to public safety, these amendments that are being proposed to the Constitution. On any given day in this country, the United States detained almost 500,000 individuals before trial, with over 60% of the US jail population made up of individuals who have not yet been convicted. This will further aspirate what's happening in our state. I feel that in some cases, what is being proposed would cause double jeopardy for individuals who have done their time, who have gotten their lives together, and for some reason there was a mistake made in most cases. Pretrial detention does little to protect the public if jurisdictions detain individuals on the basis of ability to pay rather than increases socioeconomic and racial inequities in the criminal justice system. It has been long said that individuals who are detained with even small dollar amount bills, it's devastating on their mental health and also economically. The income is not coming into the homes of these individuals. In some cases, and I'm seeing this around the country, where many systems are going to a no bail system, no cash bail system. But this further takes us back in what our legislators are asking of the judges, and that is that previous convictions are weighed more heavily in determining bail. That is something that could be hurtful to many, many individuals in our state. Some cities are considering the use of risk-based assessment tools for more accurately predict defendants' flight risks. Other cities such as New York, for example, have earmarked substantial funds to suppress low-risk defendants instead of requiring them to post bail and face pretrial detention. Pretrial detention is, as our Constitution says, we are innocent until proven guilty. Pretrial detention is without being able to bail is hard for individuals who are of low-income families. Current bail practices fail to take into account private and social costs of pretrial detention. Notably, the loss of freedom to defendants, the collateral consequences to defendants and their family members, and the administrative costs to the state. We have to look at that. Instead, bail practices should primarily reflect a concern with certain benefits of pretrial detention, namely preventing flight and new crimes if defendants are released. I'm going to end it there. I did not have my PowerPoint ready. My apologies, Sue, but I am open for questions. Thank you.
Thank you, Jerome. And I'm sure there will be questions for you. And our final speaker tonight is Jeff Mandel, who will discuss the two election-related proposed amendments. One, limiting eligibility to vote to only a citizen. The second, prohibiting municipalities from using private funds for election administration. Welcome, Jeff.
Thanks, Sue. And hello, everyone. Thank you for having me. It's a pleasure to be here. It is a privilege to frequently represent the League of Women Voters of Wisconsin in court as we fight together to ensure that all eligible voters are able to participate in our democracy. And it's also a privilege to be here tonight to speak briefly about two pending amendments involving elections. So this is the bail one. Can we move forward to one of the election ones? There we go. All right, I'm going to speak about each of these and hopefully be relatively brief, because the reality is both of them are fairly simple. And I would suggest to you that both of them are solutions that are in search of a problem. That is, we don't really have any need for these amendments. The legislature is looking to either restrict the ways that people might be able to vote in the future, or pick fights that they think are politically useful, even if there's not any practical outcome right now. So the first of these amendments, which you see on the screen, is an attempt to change Article 3, Section 1 of the Wisconsin Constitution, which guarantees the right to vote. Dustin talked about how state constitutions differ from the US Constitution. And one really important way that we talk about the Wisconsin Constitution and how it differs from the federal Constitution is that the Wisconsin Constitution expressly guarantees the right to vote. The right to vote is actually not anywhere specifically enumerated in the United States Constitution, but our Wisconsin Constitution has an entire section, an entire article, Article 3, about voting. And this is an effort to change one small part. Right now, what Article 3, Section 1 says is that every United States citizen, age 18 or older, who's a resident of an election district in this state is a qualified elector of that district. That's sort of very legalistic mumbo jumbo to say that every United States citizen 18 years or older who lives in Wisconsin gets to vote. Now, the statutes, of course, have some exceptions. There are ways in which you can forfeit your right to vote, but the basic premise, which is familiar to all of us, is that if you're 18 or over and you're a citizen, you get to vote. What this amendment would do is it would change the language of Article 3, Section 1, so that instead of saying every US citizen 18 or older can vote, it would say only a US citizen age 18 or older who is a resident in Wisconsin can vote. In other words, it takes it from being a qualification, if you are a US citizen and 18 or older, you may vote, and makes it a limitation. You must be a US citizen and 18 to vote. Now, as a practical matter, here in Wisconsin, that doesn't change anything. There are no elections to public office in the state of Wisconsin in which individuals who are younger than 18 years of age or individuals who are not United States citizens are allowed to vote. So then why does it matter? I would suggest to you that there are two reasons that this would matter and that you might be concerned, and as I understand it, that the league is opposed to this amendment, this proposed amendment. First, there are municipalities around the United States, not states, but local governments, cities, towns, villages, school boards, things like that, that have allowed non-citizens or people younger than 18, usually people who are 17, sometimes also people who are 16, to vote in elections just for those local offices. So Maryland, for example, is seen as a leader in this kind of experimentation. There are almost a dozen different local governments in the state of Maryland that have decided to let people vote in their local elections only, not their elections to the Maryland legislature, not for governor, not for Congress or president, just in local elections, who are either not citizens or are younger. The city of San Francisco, for example, has decided to allow non-citizens who are residents and have children in the public schools to vote in school board elections. These are the kinds of experiments that we usually think of as a strength of our American system, right? We have a federal system where questions of federal law are decided in Washington, and state and local laws are decided in those places. The Supreme Court famously refers to that as laboratories of democracy. This has not happened in Wisconsin, which is itself a famous laboratory of democracy, but this kind of experimentation with who is eligible to vote has not happened in Wisconsin in well over a century. But what the point of this amendment would be to prevent any local government in the state of Wisconsin from engaging in that kind of experimentation. I'm not really clear on why the legislature is so keen to preclude something that we don't really know very much about and that we haven't had any trouble with. The second reason to be somewhat concerned is if there is a limitation, if it is expressly the case that only United States citizens may vote, we might see more efforts to document who is a citizen as part of the electoral process. And that is actually grounds for concern. And let me explain why. Not because we want people who are not eligible voters to participate, and not because we have a problem with that. That's not a problem that we have now. But we already have in Wisconsin extensive and detailed election laws. We already have extensive processes that people at times find it quite onerous to meet so that they can cast their ballots. And as in the last few years, as there have been more and more fights about our election processes in courts, we have seen those processes at times get made more complex by local election officials. Wisconsin, as you all probably know, is fairly unique. We have the most decentralized election administration in the United States. Most states run their election on a state level through a Secretary of State or on a county level. But in Wisconsin, we run our elections on a municipal level. So we have 1,850 separate municipal clerks, each of whom runs their own elections. And there are positive aspects of this, and there are ways in which it makes things far more complicated, and some people see it as a negative. But we have had a challenge this past year where the Wisconsin Supreme Court said in response to a lawsuit that if you cast an absentee ballot, you need to return it to your municipal clerk yourself. Now, I would suggest to you that that's a misunderstanding of the law, but that is now the law in as much as it is what the Wisconsin Supreme Court has said. The federal courts, we went to court on behalf of several individuals, and we got the federal court to acknowledge quite clearly that there is an exception for those who are disabled and are protected by federal law. But as a general matter, the Wisconsin Supreme Court says that only the absentee voter themselves may return their ballot to the clerk's office, which raises the following interesting question. How is a clerk to know who's returning the ballot to the clerk's office? If I walk in to return a ballot, may the clerk ask me who I am? May the clerk demand that I prove who I am? The answer to that second question is no. The clerk cannot do that. It is a longstanding principle of law in Wisconsin that obviously every voter must meet all of the requirements in the election code to vote, but that election officials, including our local clerks, cannot add new obstacles to voting that the statutes do not anticipate. To be a Wisconsin voter, you must show ID. You must show ID to register to vote. You must show ID to obtain an absentee ballot. You must show ID when you show up to vote. But there is nothing in the statute about returning an absentee ballot that says you must show ID. And so this has become an issue. And in fact, Law Forward has a pending complaint before the Elections Commission against a local municipal clerk who has been requiring individuals to show ID and prove who they are when they return absentee ballots, even though there's no support in the law for that. So the League has expressed a concern that if this constitutional amendment passes and it expressly restricts voting to only United States citizens, that language that suggests that this is a problem when it's not, might also lead to additional administrative complications if election officials were to start asking for proof of citizenship. You know, one of the things we hear a lot, and you're all familiar with this, is that voter ID really shouldn't be that hard. Now, it's a lot harder than people like to acknowledge. But it is the case that many people generally carry photo identification with them. It is not the case that most people carry proof of citizenship with them. So that's what's going on with this amendment. And let me speak briefly about the second proposed amendment, if we could advance the slides. Okay, this is an amendment dealing with private funds for election administration. And let me just give a quick bit of history, and it touches on something that Dustin said when he was talking about the expenditure of funds amendment. Dustin noted that in response to that amendment, the governor's staff has invoked the COVID period when the legislature didn't meet for more than 300 days. You might remember that early on, when COVID was new, Wisconsin had the first pandemic election in the United States. It was our spring 2020 election. It was in April. And it was also the Wisconsin presidential primary. We were the first state in the country to have an election where people needed to get out to the polls and needed to be able to vote, while we also had a safer at home order. And we had this new pandemic that everyone was acknowledging, but nobody knew nearly as much about then as we know now. And so you might remember Speaker Voss of the Assembly has a laudable habit that he often volunteers as a poll worker. And there was a photo of him wearing full protective gear and looking almost like he was ready for a moonwalk while he was telling Wisconsinites that there was nothing to fear. There was no reason not to come out to the polls. As part of preparations for this election, the Wisconsin Elections Commission, the many municipal clerks and election officials, and the governor pleaded with the legislature to come into session to deal with and help provide guidance on how Wisconsin was going to have this election in the midst of the pandemic. They asked, there were proposals that the election should be postponed until the health situation got a little bit better. There were proposals to send absentee ballots to every registered voter. There were so many different kinds of proposals. The legislature did not come into session to do any of this. And one of the things that came out of that was that you had municipalities after that April election who had spent all or almost all of their budget for the year to get personal protective equipment, to make sure that they had made the voting places as safe and as clean as they possibly could. And they still had both an August primary and the November 2020 general election to plan for. The result of the consequence of that was that a national nonprofit group called the Center for Tech and Civic Life brought hundreds of millions of dollars to bear and said to municipal governments and states all around the country, if you need money to run your elections safely, we're going to make grants. Give us proposals. And what you might remember is hearing a lot over the last few years about how Wisconsin's 5 largest cities, Milwaukee, Madison, Green Bay, Kenosha, and Racine, received grants from the Center for Tech and Civic Life to help run safe, clean elections in the fall of 2020. And that's true. They did. What you might not hear nearly as often is that 200 other municipalities in the state of Wisconsin also received grants from the Center for Tech and Civic Life to run safe and clean elections. You might not often hear that every single municipality in the state of Wisconsin that asked the Center for Tech and Civic Life was granted money, and every single municipality that asked was granted every penny that it asked for and provided a budget explaining how it would use. Nonetheless, as part of the tremendous controversy surrounding our November 2020 election in this country, there are some who have objected to these grants as improper. There has been litigation in state and federal court in Wisconsin challenging the Center for Tech and Civic Life grants. That litigation has uniformly failed in state court, in federal court, in front of conservative judges, in front of liberal judges, before the election and after the election. And Wisconsin is not alone in this. There was litigation in at least half a dozen states about these grants, and every single state, every single case has said that the grants did not violate either state law or local law or the state or federal constitution. And yet, these grants remain controversial. President Trump and others have continued to criticize these grants and claim without basis that they were used for partisan purposes. And that is what this amendment is about. This is an amendment that would prohibit state or local officials from asking for, accepting, or using any private money to run elections. Now, you might say, well, that seems fine. As long as we know what the rules are, what's the problem? And I guess I would suggest this to you. We could very well have a situation again, I hope not, but we could very well have a situation again like 2020, where municipalities did not have money to run elections. Elections are the most fundamental building block of our democracy and our society. We have to have elections, and we have to have elections that are free and fair and open to all eligible voters. If the legislature wants to guarantee that elections and the needs of election officials will always be fully funded, then that is one thing to then turn around and cut off other sources of funding. But in the absence of such a guarantee, and there is no such guarantee forthcoming or on offer, in the absence of such a guarantee, it strikes me as unwise to create a blanket rule and put it in the Constitution, which makes it much, much harder to change, right? Think back to what Dustin talked about how we amend the Constitution. It has to pass the legislature. Then you have to wait until we have a general election that changes all the members in the assembly and half the members in the state senate. And then in that new legislative session, it has to pass the legislature again. And then you have to wait for the next election so that it can go to be ratified by the people. It's not so easy to change the Constitution. It's easier than it is to change the US Constitution, but it's still not so easy. I would question the wisdom of putting into our state constitution such an ironclad prohibition on this kind of funding when there have been circumstances within the last few years, and it is foreseeable there could be circumstances again when such funding is necessary. So that's the story with the two election amendments that are pending. And with that, I'll stop speaking and listen to questions both for me and for Dustin and Joe.
Sue, you're muted.
Okay, I thought I unmuted, but thank you for letting me know. Julia, could you bring the slides back and go to the slide on the bail proposed amendment? I just wanted people to see that and run through it very briefly. Okay, great. So basically this is the language of the proposed amendment, and pretty much it does two things. I mean, it talks about pretrial detention and it talks about bail. And in both cases, what is being done is, first of all, changing the criteria of serious bodily harm, deleting bodily so that it's just serious harm, and inserting as defined by the legislature by law. So this puts control in the hands of the legislature to define what serious harm might be. And then in the second underlined part, that introduces new requirements for bail and also includes the language at the bottom, from serious harm as defined by the legislature by law. And so this is taking some control away from judges who now make these determinations and giving it to the legislature. Now, since these requirements that are written, that they wrote into their proposal, require the legislature to pass laws, I assume those laws would be subject to veto, and it is not at all clear to me what would happen in the event that the legislature did not define what serious harm is or did not define what a violent crime is. And I think those are open questions. So we can take this slide down and we will now go to the audience questions, and there are many. So the first one has to do, I mean, they're kind of in order of our speakers. So the first has to do with the amendment regarding the governor's authority. And the question is, would this amendment apply to settlements to lawsuits, such as those related to the opioid crisis and tobacco companies?
This and some of the other questions are kind of asking for predictions about how the amendment would be interpreted and applied. And I'm a little hesitant to do that. I will kind of do my best, but with just kind of the big caveat saying, you know, everything is subject to interpretation, and my answers certainly aren't definitive. Now, in terms of the settlements for litigation related to the opioid crisis and tobacco, I don't believe that would be implicated. Those kinds of settlements would be implicated by this amendment. The amendment, it talks about federal monies and the funding from those settlements that would be coming from the defendants in those cases, which are, you know, private companies, and just the entire process that's in play with, you know, settlements of litigation. It's a completely different process from the process of receiving federal funds. So I don't believe that would be implicated by this amendment.
And then there's another similar question regarding the expanded Medicaid money.
Yes. So the question was, if the Constitution is not amended, would expanded Medicaid money from the federal government be allocated to the citizens of Wisconsin by the governor or legislature? And it goes on to say the ACA expanded Medicaid money was not accepted in the 2013-14 by the governor at the time. So I'm on especially shaky ground when it comes to questions about the Medicaid expansion, which is not something I know very much about. So again, with that caveat, my understanding is that in order for a state to accept expanded Medicaid money, the state has to actually expand Medicaid eligibility, and that's something that requires an act of law. And in Wisconsin, an act of law would have to originate with the legislature. There are some states that have direct democracy provisions that allow citizens themselves to propose legislation or amendments to the Constitution, where citizens have proposed changes in law to force the state's hand to accept expanded Medicaid money. So in those states, that happened through direct democracy, and then, that changed the law in those states. For Wisconsin, again, the legislature hasn't acted on that front. So I believe that inaction by the legislature is what's kind of affecting the Medicaid expansion. So I don't know that this amendment would affect that at all.
Okay, thank you. And then finally, a question, do any states give their governors unfettered rights to spend a fixed percentage of the federal allocation without recourse to the legislature?
And so the answer to this is yes, in terms of the states in which the governor does have some authority to act without to the legislature when it comes to allocating money. So there are states that kind of tie this to a percentage. One example is North Carolina. The percentage there, it's not a percentage of the federal allocation or the federal funds that the governor is given free rein to allocate, but rather any unanticipated funds within, I think, 3% of the state's budget, the governor can appropriate based on his own discretion. So that's kind of a slightly different scenario. It's based on a percentage of the entire state budget, but it is kind of saying, look, you have discretion, kind of constrained discretion, to allocate a certain percentage of money.
Okay, thank you. And then for Jeff, we have a comment on the citizen proposed amendment. The legislature is raising this to demonize the immigrant community and raise the specter of undocumented people voting. Do you have any reaction to that comment?
I think, unfortunately, that's probably accurate. I mean, I think that, as I said before, I think that part of this is going to perpetuate what we've seen over the last few years, which are unfounded claims about voter fraud or calling into question our elections when we have exceptionally well-run elections in this state, and there's really no basis for calling them into question.
Okay, and then a somewhat related question. Are similar laws, referenda being introduced in other states? Are these templates that are being drafted by a national organization? Have similar laws amendments passed in other states?
It's a great question. We are seeing extensive efforts across the country to limit and constrain voter rights. And in fact, Law Forward, in conjunction with two national organizations, Protect Democracy and the States United Democracy Center, has put out a report and several updates over the last couple of years to follow this just complete bevy of attacks on voting rights around the country. And these efforts to diminish. I suspect, although I can't say for certain at the moment, I suspect that especially the effort to limit outside funding is something that we're seeing in several states, because as I said, there were lawsuits in multiple states, and those lawsuits uniformly failed. And those lawsuits were all involved the same lawyers who are here in Wisconsin. And so I expect that they are heavily engaged, not only with the Wisconsin legislature, but also in other places where they are pushing to get similar policies through. In terms of the citizenship piece, we are seeing similar efforts in a couple of other states, and there are other states that either have long restricted voting only to citizens or that are also talking about doing so for the first time. What we haven't seen, to my knowledge, is one of the states where this kind of experimentation is happening, where they've decided that it's a bad thing and they are therefore limiting voting rights. It's not really about limiting voting rights, it's about limiting the ability of local governments to decide that they want additional members of their community who don't have voting rights more broadly to be able to participate in the governance of their community. And we're not seeing, to my knowledge, any state where this experiment has been tried that has found that this is a bad idea or that it causes trouble and tried to ramp it down or step back away from it. We're just seeing it in places where it has never been tried, and really where it is primarily a way to create fear and to sow distrust in our elections.
Okay, then we have another question about that amendment. If the constitutional provision that guarantees the right to vote for every citizen is amended to remove that word, wouldn't that be a critical difference that would weaken the Wisconsin right to vote? And there's a somewhat related question. In terms of the only a United States citizen language, would this not allow the legislature to pass a law further restricting voting? For example, could they pass a law restricting voting to, say, property owners, which are not a protected class?
So these are great questions. I certainly don't think, in response to the first question, I don't think that any of the sponsors of this proposed amendment intend it to weaken the right to vote. I do think they're trying to ensure that the kind of experimentation I was talking about before doesn't happen. Excuse me. That said, I think these two questions taken together offer a helpful example of how in the future someone might argue that it's weakened the right to vote. Because right now our state constitution guarantees that every United States citizen 18 or older has the right to vote. And after this, it wouldn't promise that every United States citizen had the right to vote. So would it create the possibility for some kind of mischief or shenanigans where the legislature or someone else through litigation tried to limit which citizens would have the right to vote? I certainly hope not. And we have an equal protection clause, both in the federal constitution and the state constitution, that as currently understood would prohibit anything like that. But it is, I would not have predicted some of the cases, some of the judicial decisions we've seen in the last decade, and I can't really venture to say what would happen in the future. So I certainly understand the concern and think that it's a fascinating question.
So let me ask you one follow-up on that. Regarding the requirement or the potential requirement that proof of citizenship be provided when someone is voting. What I understood you to say is that could not be done unilaterally by election officials. It would have to either be done by the state legislature, which presumably they could do without this amendment, but at any rate, it would have to be done by the state legislature or by a court. Is that right?
I think that's right. And keep in mind, when we talk about doing it by the state legislature, it would have to be done through lawmaking, right? So that requires, if we think back to Schoolhouse Rock, that requires a majority in both the Assembly and the Senate, and then the governor's signature, or if the governor vetoes, a supermajority in both chambers to override. So yes, it is undoubtedly true, Sue, that if the legislature really wanted people to need proof of citizenship to register to vote or to actually go and cast a ballot, that could be done by statute, but they would need a cooperative governor. And right now we have a governor who was just reelected who has been completely steadfast in defending the right to vote against some of the whole range of attacks that I've already talked about in the last few years. Governor Evers has said, absolutely not. On my watch, everyone in Wisconsin who wants to vote will get to vote, and we will not make it harder or in any way weaken the right to vote in Wisconsin.
Okay, the next question is really addressing the amendment regarding the private funding. And I just wanted to clarify so people know, people may already know this, but that that foundation, the Center for
Tech and Civic Life.
Yes, thank you. That's the Zuckerberg Foundation, where the Zuckerbergs are involved with it.
So Mark Zuckerberg, who is the founder and primary shareholder, I suppose, in Meta, which most of us still think of as Facebook, and his wife, Dr. Priscilla Chan, their private foundation gave, I believe it was $300 million to the Center for Tech and Civic Life, specifically for these grants to award to governments to help make sure that there were safe and clean elections in 2020. And so people have talked about this as the money coming directly from Mr. Zuckerberg. That's not exactly the case. The Center for Tech and Civic Life is a foundation. It is a nonprofit, nonpartisan organization that is governed by the extensive tax laws in the United States and in the state where it's set up, that ensure that foundations operate in specific regulated ways. But yes, there has been much made of the fact that a lot of the money originated with Mr. Zuckerberg.
Okay, so getting on to the question about this. I can see where a rural government has a voter with a disability who needs a ramp to enter a polling site. They find out a Center for Independent Living can lend a portable ramp to make the site temporarily accessible. This proposal would prohibit that, wouldn't it? Or would it not?
Hold on, I'm looking at the text. We lawyers are annoying that way. I think it might. I don't think it, again, I think this is a really perceptive question. I don't think that that's necessarily the intention. And I think if you spoke to legislators who favored this, they would say it doesn't. But if you look at the text, it says, no state agency or officer or employee in state government, and no political subdivision of the state. That's the legalese for a local government, right? So no local government or state or employee of a local government may apply for, accept, expend, or use any monies or equipment. So you may not use any equipment in connection with the conduct of any primary election or referendum if the monies or equipment donated or granted by an individual or non-governmental entity. So I think that is exactly correct, that if you had a small town and they needed a ramp, or they needed new, better stairs into where they were holding voting, or whatever it might be, and someone volunteered to make that, that would be a violation of this constitutional amendment.
Okay. The next comment is, to assure elections are fully funded, legislatures should pass an amendment that mandates full funding.
I would just note that they can do this. The legislature uses something in every budget, at least going back a generation or two, called some sufficient funding for itself. What that means, some, S-U-M, not S-O-M-E, some sufficient funding. What that means is they grant themselves an allocation of money, a pot of money that is sufficient to meet whatever total amount of money they decide they need to spend in running the legislature. And one of the things we've seen in the last few years is the legislature has become extremely litigious, and they've hired outside lawyers for a number of things, and they pay those lawyers usually about double what the state government pays lawyers. If I or my law firm works for the governor, for example, we get paid a flat rate by the state. The legislature pays more than double, and it doesn't matter what it costs because there is a bottomless pit. It is some sufficient. They get to spend whatever money they decide they need. And certainly the legislature could do that for the Elections Commission. or could do that by setting up a similar pot for local election officials. And they do not. To my knowledge, I'm not an expert in the budget, but I'm not aware, let me put it that way, I am not aware of any other portion of our state government that is funded on a sum sufficient basis.
Okay. The next question is regarding recall petition signers. Must they also meet the citizenship, age, and residency requirements?
I believe so. I'm quickly opening my statutes here, but my recollection is that to sign a recall petition, you need to be an eligible voter. So you can sign a recall petition for any official for whom you would be eligible to vote in the next election, or if that election were held that day.
And would that also apply to signing petitions for people who are intending to run for office?
Yes, for nominating petitions. And since we're talking about it, I will just note one of the things that's in Wisconsin law that very few people know is it is against the law to sign nominating petitions for multiple people running for the same office. So, and that's not an obvious policy. I mean, I personally think that people who want to be on the ballot and want to run for office should be able to do that. So I personally would have no problem signing nominating petitions for multiple candidates, even if I didn't necessarily think I would personally choose to vote for each of them, but that's illegal. So be careful.
Thank you. Doesn't the Constitution require 3 branches of government which will have equal powers? These changes seem to shift the balance of power from the executive branch back to the legislative branch. Can someone comment on this inconsistency? Why don't we give Jeff a break and turn this one over to Dustin?
Sorry, I was responding to another question in the chat. Can you tell me again which question you're talking about?
Doesn't the Constitution require 3 branches of government which will have equal powers?
Sorry, sorry, what is that in reference to?
The changes.
Is that the extent of the question?
No, there's more. I'll read the rest. These changes.
Which question? I can look it up myself too.
These changes seem to shift the balance of power from the executive branch back to the legislative branch. And that certainly applies in the amendment regarding the governor's authority. So
sorry. So if I'm understanding the question correctly, and it's just kind of a question of, we have a balance of power and we do have 3 branches of government. Yes, the Wisconsin Constitution, it creates 3 branches of government, and each branch of government acts in its own sphere. The Constitution also dictates, what the nature of that relationship is, what power each of those branches wields. And so amending the Constitution is a way to change that balance of power. It's not like it's eliminating a branch of the government. We still have 3 branches of government, but it's just kind of a shift in the way that power is allocated.
So you don't think that argument would be a basis for challenging the constitutionality of
the argument that it's unconstitutional because
because it's undermining the authority of the executive branch?
No, I don't think that argument would hold water, because it could when it comes to legislation or ordinary statute. This kind of goes back to what I was talking about earlier in terms of the significance of amending the state constitution. That is the fundamental document that creates the branches of government and designates what their powers are. So if the legislature wants to change that balance of power, it has to do so by going to the Constitution itself. But so a change in the Constitution itself would not itself be unconstitutional, at least under the state constitution. The state constitution does have to comply with the federal constitution.
Okay. And then another one regarding federal funding. If a major new federal grant opportunity came, say, for repairing more bridges, would this block the DOT from applying for that since it wasn't in the budget?
So it's hard for me to say, because you're talking about, this question has to do with whether or not the DOT would be able to apply for that funding. So that's kind of an initial step before actually getting the funding. And I can't say. I mean, this certainly seems like it's something that would that this amendment would implicate. And ultimately, I think what the amendment says is that the legislature has to play a role. I mean, it's again to do what Jeff was doing, to look back to the language of the provision. The governor may not allocate any federal monies without the approval of the legislature. So it doesn't say that the executive can't apply for funding. It just simply means that there's an additional step of getting this approval. So if the Department of Transportation had applied for federal funding and it was granted, then presumably what would happen is legislative approval would be sought, and then the legislature would choose to act or not act.
Okay, the next question is one for me. How is the League of Wisconsin planning to advocate for the rejection of these ballot measures when, if they're passed by the legislature? Well, this is the first of our efforts in that regard, and that is just to simply educate people about these amendments, because until now, I think they've mostly been under the radar and people aren't aware that this could be coming up. We will also be planning statewide education. We will have flyers that will be produced electronically and then sent out to all of the local leagues so that they can produce them physically if they want, and distribute those in their communities. So that's one thing we will do. We will also be preparing statements, writing letters to the editor, etc. Everything we can do to publicize this. All right, then a question on the bail amendment. Will the legislature have to define serious harm before the citizenry vote on the proposed bail amendment? And my answer to that is, the way I read it, no. The legislature does not have to define what serious harm means until after this amendment would be passed. Jerome.
Yes, you're correct, Sue, and that is not good. Not only the serious harm, but also violent crime is something that that was stricken, that they're looking to define. Sorry about that. You're correct, Sue.
Yeah, the real question I have, and I don't know if anybody knows the answer to this, but so what happens, if the legislature passes something to define serious harm and it's vetoed, then what? Where are we? I don't know if Jeff or Dustin have thought about that at all, but it's one of the reasons I think this amendment is problematic, because it seems to me it's not at all clear what would happen in that situation.
And Sue, I want to add that, we saw this happen in Truth in Sentencing. There's 3 versions of that, because it was not spelled out but passed. The Truth in Sentencing, and there's Truth in Sentencing 2, which many individuals are, incarcerated under since 2000. But just, looking at the bail amendment, if it's not defined by the legislators, not defined by the judiciary, we're going to run into some of the same problems with defining serious harm and violent offenses.
Right. And the next question is addressing that issue. How are these amendments written for the ballot so that the citizenry can understand them? Marcy's law is a real problem because it was not fully understood by the populace when it was approved and has been challenged in the Wisconsin Supreme Court. We just at the end of last week saw the language that they are going to be using. And actually, I can distribute that to everyone who is attending or has registered for this webinar. So I will distribute that language, but I think that is a serious problem. Jerome, do you have anything to add to that?
No, I think you captured that well. Yeah, Marcy's Law, yeah, it's impacted it's impacted a lot of individuals who are in our system. And many have been put on GPS monitoring because it was not defined when our former Attorney General added some things that put individuals on lifetime GPS.
Okay, we have another question.
Sorry, and I was just going to chime in on that point. You know, with respect to Marcy's Law, the Marcy's Law amendment was also just an actually very long provision that was added to the Constitution. So trying to sum that up and capture it in a ballot question was especially challenging and fraught. These amendments are not nearly as long. So one might think, okay, maybe it's going to be a little bit easier. But just now, you know, I'm looking at the language that was proposed for the question regarding amendment. And one concern that was an issue with Marcy's Law, which I think, again, could be a concern here, is that the ballot question doesn't necessarily show you what this is changed from. Like, what had the Constitution said, it instead just tells you what it's saying now. And so without that sense of like, what is this actually changing, it's hard for a voter to have a true understanding of the implications of it. And in addition to that, there's all the interpretive questions that we've been talking about, where, you know, it's impossible, you know, even for lawyers to be predicting the implications of these. So to expect a voter to really be able to kind of look ahead and understand that, you know, that's asking a lot of the voters. So converting proposed amendments to ballot language is a very challenging process.
Thank you. Another question on bail. How would the bail amendment affect jail overcrowding in Wisconsin? And would it end up keeping people in pretrial detention who may eventually be found to be innocent, but will, once they are acquitted, have then lost their jobs or been evicted? Jerome, you want to answer that?
Yeah. Well, for sure, one thing that's bad about it is I know that they're proposing looking at and stronger consideration in former convictions. I know early on that they had a minimum amount attached when they first introduced this bail reform. There was a minimum dollar amount attached to individuals who have been convicted of a previous violent offense that they're held under a $10,000 or $40,000 bail automatically, and that would across the board, it would just affect so many people. And yes, it would cause jail overcrowding, especially without violent crime and substantial harm not being defined. I feel, and I'm not a lawyer, but I feel that yes, it would cause more pretrial detention, looking at history, and is bordering double jeopardy to a certain degree.
And it appears that that's the intention, in fact, of this proposal. Regarding the amendment to change the bail requirements, could this be applied to protesters? So I think, I mean, again, that depends on how serious harm is defined. Since they are proposing to remove the bodily qualification from that criterion, I mean, I don't know what the limit would be.
I agree.
And then on Illinois has eliminated cash bail. Is that a good thing? What is different about this proposal relative to Illinois?
Well, I know that the Supreme Court did step in on the Illinois no bail, no cash bail hearing. So I'm not sure of the outcome, but that's what many states, New York and many other states are looking at, and that is no cash bail. So let me look at the question here.
And they're asking if that's a good thing.
Oh boy, I don't know what's going on. My lights seem like they're going out more and more. So I'm waving here. Change the requirement.
Is that something that your organization supports?
Yes, it
eliminating cash bail?
Yeah,
Okay.
it is.
So what is the position of the League of Wisconsin on the bail issue? Well, the League opposes the proposed amendment, and the reason for that opposition is some of the things that we've been talking about here. It seems somewhat unworkable. It is intended to detain more people before their trial, before they have been convicted. Okay. Who determines the text that ends up on the ballot regarding these amendments if the text of the amendment itself is not included? And that's the legislature, right, Dustin?
Yes. So we talked about the 3 steps of the process to amend the Constitution. The first step was just the language of the amendment, which the first session of legislature approves. Then the next session, the legislature has to again approve the same exact constitutional language, but it also, the joint resolution that both houses adopt also includes the language that is going to appear on the ballot. So when I was talking before about the language for the bail amendment, that is the language that appeared in the joint resolution that was proposed for this current session of the legislature, just kind of came out a couple of days ago. So it is the legislature that decides that.
Okay, so we are pretty much out of time. There's a couple of more questions here, and maybe you could type answers in quickly to those people if you could.
Or if you wanted, I could quickly, I see that there is a follow-up to the question about the kind of balance of power. The question being, how does requiring the governor to get approval from the Wisconsin legislature not undermine the governor's authority? It does undermine the governor's authority. But I think the initial question that I was responding to was, well, doesn't the Constitution require 3 branches of government which have equal powers? And the answer is, well, it requires 3 branches of government, but it doesn't explicitly say they have to have, perfectly equal powers. There's the Constitution itself dictates what power each branch has. So this would be a change to the Constitution that does affect the balance of power, and it shifts more power from the governor to the legislature. So yes, it would undermine the governor's power here.
Okay, thank you. And thanks to all of our panelists and to all of our audience members for joining in this forum. The League's discussion units will be meeting next week to discuss the issues presented. Information about how to join a discussion unit is on the League's website, lwvdanecounty.org. Resource materials containing more information and links to organizations working on these issues can be found on the League website. Technical support tonight has been provided by Julia Gilden. This forum was planned by a work group of Tori Sheldon and Dan Stapleton, and Amanda Hingst assisted with resource material editing and formatting. Thanks to all of them. Future forums that we have coming up: on February 9th, the impact of Wisconsin Supreme Court cases, and on March 9th, judicial integrity. should judges decide cases involving their campaign contributors. And these are, of course, looking forward to the April 4th election for a Supreme Court justice. We also have advocacy work groups on these and other topics. If you're interested in that, you can contact me at program@lwvdanecounty.org. Thank you all, and good night.